Hi, does our clock over there say 5:10? Oh, okay. Good morning, everyone, and welcome to a interesting session of oral argument in the 5th District Court of Appeal. As you've already heard, I'm Judge Griffin. To my right is Judge Orfinger, and to my left is Judge Torpy. There were four cases on the docket this morning. The second case has come off. We'll hear the 9:30 case, and then we'll go off and have a change of panel, and at 10:30 we'll do the third case on the docket, and then we'll take the fourth case in order with yet another change in panel. It's a veritable grab bag of judges today. So if you don't like who you got, stick around. First case on the docket is BVC Partners versus EMERAL GABLES, and I can see that counsel are raring to go, so you can begin whenever you're ready.
May it please the Court, my name is Lee Morrison with Gray Robinson, PA, on behalf of Petitioner BVC Partners 1 LLC. Which respectfully request 2 minutes for rebuttal time.
Okay, I'll try and help you keep your time.
Thank you, Judge. Your Honors, we're here on certiorari.
Let me ask you, Mr. Morrison, to first just explain to me as a practical matter, what does the lis pendens do to the title of the property that the recorded contracts didn't already do?
Your Honor, I think in this instance, it casts a cloud on that title. Because
how is the cloud any bigger than the cloud that was cast on the title by the recorded contracts? In other words, in the real world of real estate transactions, don't the recorded contracts put a buyer on notice that there may be a claim to the property by the putative purchasers?
Generally, Your Honor, I believe that's true under Florida law. However, under the Mohican Valley test from this court, I don't believe that the recorded agreements put third parties on notice, for the simple reason that the parties never agreed to the purchase and sale of only the acquired undeveloped property, nor did they agree to a purchase price. And it necessarily follows that if they didn't agree to that, there's no description of only the acquired property.
So you think that if you get I'm sorry, I'll yield to Judge Orfinger.
But the point is, since you're here on cert and we're trying to determine the level of harm that you might have if the LP stays on the property, and as a former real estate lawyer, I can't imagine that any real estate attorney or title examiner worth his or her salt would approve the title with those recorded contracts out there. I mean, even if the contract shouldn't have been recorded, the world is on notice that there's someone who claims an interest in this property, with or without that LP. So it seems to me that until you resolve their specific performance claim and get that wiped out one way or the other, you've got a messed up title. Now, whether you've got a slander a title claim against them, if they've slandered your title, that's a different story. But I'm trying to understand, since our focus is on the lis pendens and not on the recordation of the contracts, I come back to the irreparability of the harm, given what Judge Torpy said, that, even if we wipe the LP out, you've still got those contracts there, and I just can't imagine there's a lawyer in the world that would insure those titles.
Two things, Judge. I think if you look at the recorded agreements, they don't specifically identify the real property. They reference a Schedule 1 that refers to Arabic lot numbers, and then there's a lot spreadsheet called Gables on the Green Subdivision Lot Layout. But there's no legal...
They identify the name of the owner of the property, right?
They do, Judge, but
isn't that the way they do title searches, by name?
I believe so. I'm not a real estate lawyer as a transactional lawyer, but they don't provide a legal description of the property. How would a third party know that the acquired property is encompassed under these agreements? Curiously, attached to their notice of lis pendens, they do attach the legal description of the acquired property. The other point, Your Honor, Judge Orfinger, is that what's at issue here, though, makes this a little bit different, is we're talking about whether Emerald Entities has the right, as a matter of law, to maintain this lis pendens based upon the agreements as duly recorded instruments. Based upon the trial court's holding, it abrogates my client's right to address irreparable harm and say, I need a bond to protect me.
Well, but you know, I think we got to break it down into two bits. As I understand the law, if the action is founded on a duly recorded instrument, they're entitled to an LP as a matter of right without the requirement of a bond.
Yes, Your Honor.
On the other hand, if it isn't founded on a duly recorded instrument, but there's a fair connection, a fair nexus to the property, then they're entitled to an LP in the discretion of the court with an appropriate bond, if any.
Yes, Your Honor.
If I understand what transpired at the hearing, you all conceded that the action was founded on a duly recorded instrument.
No, they conceded that they were duly recorded instruments.
You
conceded that they were duly recorded instruments. Your contention was that the action wasn't founded on those instruments.
That's correct, Your Honor. We conceded that the agreements had been recorded, but that the specific performance claims were not founded upon.
Well, did you concede that they were duly recorded instruments, as that phrase of art is used in the lis pendens statute?
Your Honor, I'd have to go back and check the hearing transcript, but I don't believe my co-counsel conceded that they were
It says in the transcript, as far as our arguments are concerned, Your Honor, we agree that the agreements themselves are duly recorded instruments.
Very well. But, Your Honor, I don't think that's dispositive of this certiorari review, because still Emerald Entities had to show that the claims were founded upon. And if we
Well, if they weren't founded on these contracts, their claims, what were they founded on?
Well, our point, though, Your Honor, is that it may be upon remand that Emerald Entities can show a fair nexus and some right to maintain the lis pendens. But under the exception under 4823 subsection 2, the matter of right to maintain the lis pendens, the Supreme Court in the American Legion case has said that the proponent of the lis pendens must establish the strict requirement that the lawsuit is based specifically on the terms and provisions contained in the recorded document. Well, if we look at the agreements, and if we isolate the agreements and look at what the agreements contemplate, the agreements never contemplated the conveyance of only the acquired property.
So if I have a contract to buy a lot from a builder, and it's a really nice lot on the river, got nice oak trees, the builder's going to build a house there for me, and the builder defaults and doesn't even break ground on the house. You mean I don't have a right to specific performance of the real estate?
Your Honor, I think in that instance you would, because we're only talking about a single lot that's easily identifiable. In this case, we're talking about the acquisition of a whole lot of land, tracts of land from third parties. My client, BVC, only acquired a little portion of that land. Well, the agreements between the parties don't contemplate conveyance of just that little portion of the acquired property. So under the American Legion test, the trial court should have looked at the recorded agreement and said, do the terms and provisions of these agreements provide for conveyance of only the acquired property? Did the parties agree to a purchase price? No, the agreements don't. So under the threshold determined...
That sounds to me like you're arguing the merits of their claim.
I disagree, Your Honor. I think that it's applying strictly the American Legion test, which says we look at the claims filed and we ask ourselves, are they founded on the agreements? And what are, strictly construing the agreement, what are the terms and conditions and the provisions in that agreement? If it's not in there, we go on to step 2. And the court asks, well, can the proponent establish a fair nexus? But, Your Honor, just to build upon your point, one other thing, I think under this threshold determination, the trial court is permitted to test the sufficiency of the specific performance claims. This court has certainly done so in the New Vision case, a 2007 case, in which the court held that specific performance claims based upon a letter agreement that identified the parties, described the properties, but had a sliding scale for the purchase price was insufficient to maintain the lis pendens. So I think that the trial court erred by not testing the sufficiency of the specific performance claims under this threshold determination. It certainly makes logical and
Did you
practical.
have an evidentiary hearing or a non-evidentiary hearing?
Non-evidentiary hearing.
But what does that mean? Does that mean that the trial, that the essential facts, the material facts were stipulated to?
I believe so, Your Honor. That's correct. And the court only made a legal determination.
I got confused by your petition where you have made some statements in there that were supported only by the motion to discharge and not supported by any evidence. What bearing does that have on our determination here?
Well, Your Honor, I think, first of all, it was background.
And we can't resolve fact disputes that are asserted in the briefs that were not resolved by the trial judge, right?
That's correct, Judge. I think that that should be of no concern for the court because the trial court was rendering an opinion based on a question of law, whether or not the agreements are founded upon the duly recorded.
But in order to do that, your client agreed that they were duly recorded instruments, so that issue was resolved by agreement. The only other issue is this particular claim founded on or based upon those contracts, right? Isn't that the only other issue?
That's the narrow
Can't
issue.
you just look at the four corners of the pleading to make that determination?
Your Honor, I think that that's not in accordance with precedents of this court because as I just referenced the New Vision case, I think it's entirely permissible for the trial court at this threshold stage to look at the sufficiency of the specific performance claims. In our case, I think that the parties never agreed to the essential terms, the conveyance of the acquired property.
Kind of combining a dismissal for failure to state a cause of action and a motion to discharge at the same time.
And Your Honor, there's certainly been at least dicta out there where courts have questioned that. And I think the problem is, though, that, in all of the cases before this court, the court has challenged the sufficiency of the claims. It's not ruling on a motion to dismiss. And I believe that the Florida Supreme Court in the Chiuoso case, I'm not pronouncing it correctly, agreed in part with this court and said, you're right, we're not just looking at the bare allegations of the complaint, but we don't agree with you, Fifth District, that it's not the quantum of proof that you say is necessary, a substantial likelihood of success on the merits. So it's somewhere in between that the court is permitted to test the sufficiency of the specific performance claims. And in this case, we argued below that the specific performance claims could not suffice to maintain the lis pendens.
Because your client can't perform?
No, Your Honor, because we can perform, and I think that's a hotly contested issue in the lower court.
Well, we didn't contest that issue below, right? I mean, we didn't have an evidentiary hearing about
That's correct.
Who breached and all that stuff. But in a theoretical sense, is it your contention that they're not entitled to specific performance because your client could not answer the order? Your client couldn't perform because your client doesn't have all the property. Is that your argument?
No, Judge. I think that our argument
Indulge me.
Our argument is that as a matter of law, the specific performance are insufficient. If you look at the New Vision...
No, but answer the because part. I mean, what do you mean as a matter of law? It's because what?
Because the parties did not agree to the essential terms that are alleged based on the specific performance. They never agreed in the 8 agreements to the conveyance of only the acquired property. They never agreed to a purchase price for only the acquired property. And
but if you follow that through, doesn't that reward, again, assuming that their allegations are correct for the moment, wouldn't that reward your client if he decides, for example, well, I can sell this off to somebody and make a lot more money, I just won't perform because the contract contemplates completed construction, not just bare property, and just say, well, we never agreed to it, so the deal is off. I mean, doesn't that come back to Judge Torpy's example where he has a contract to buy a lot and a house. He wants the lot on that house, but the builder won't build. You're telling me that he's not entitled to a specific performance to buy that land. I mean, I just have a hard time, if it's an equitable action, to accept that theory.
Because the price was based on delivering the land and the house, so there's no price set for the land without the house. And I mean, it seems like the same arguments that you're making here would obtain in my example that I gave.
Except, Judge, I believe that under these contracts, my client was to do much more than simply erect a house on a lot. We have involved in this deal infrastructure improvements, subdivision improvements, profit on top of that.
That's all just performance, though. I don't understand why, in logic, my example does not apply in this case.
I think if we go strictly to the agreements, the parties never agreed to the conveyance of just raw land. Mm-hmm. They agreed to so much more, lots, and dwellings erected on those lots to comprise the homes.
In the example that I gave, the homeowner's remedy is to either sue for damages, right? The difference between the contract price and the value, or whatever the measured damages is, or sue for specific performance, obtain that which the seller is able to perform, in this case the lot, and then get ancillary damages for the cost of completion of performance. Wouldn't that be, in my example, wouldn't that be the remedy available to the purchaser?
I think it would, Your Honor.
Okay, why isn't that remedy available here? To sue in specific performance, to force the conveyance of whatever portion of the property your client has in whatever state it's in, and then sue for damages to complete the performance.
Your Honor, I think the distinction is, in this case, the agreements call for so much more, the acquisition of a whole lot more land, subdivision improvements, infrastructure improvements, profit on top of that, and only then is my client required to convey the lots and the dwellings. But in this instance, Emerald Entities is trying to compel just conveyance of the acquired property.
Well, I think that your answer, though, kind of dodges the question. I mean, I understand your point, but that seems to go to the question of how do you calculate the value of the raw land, assuming that they were able to get specific performance. How do you calculate the value of the raw land separate and apart from all of these other things? It seems to me that the problem that you present is not a legal problem, but a matter of proof. It's a proof problem. How do you break them out? But the fact that you were supposed to, in Judge Torpy's example, it was fairly simple. You build a house on this lot and you sell it to me. And if the builder refuses to build and I get specific performance of the lot, it's fairly easy to calculate my damages. Now, in your case, it may be a whole lot more difficult to calculate the damages and to calculate the value of the property alone, but it seems to me that just as a legal proposition, I don't understand why Judge Torpy's example doesn't apply. And what you're telling me is, well, our number's a whole lot bigger and it's a much more complex transaction. I accept all that. But as a matter of logic, I don't see why the same rule doesn't apply.
Judge, I think in short the answer is to get that result, it would require the trial court to modify, alter, or amend the agreement between the parties. Essentially, the court would be...
Isn't that what in Judge Torpy's example, isn't that exactly what happens? The builder won't build the house, and I want the lot. So the judge is going to have to go in and say, well, this was $1 million deal. Based upon the evidence I've heard, the lot's worth $400,000. You pay him $400,000, and the lot is yours, and then we'll work on the damages later. I mean, isn't that what judges do?
Well, but Judge, I think that in this instance, the parties didn't agree to what's being sought by specific performance.
I agree with you, but I'm still trying to get you to tell me why the same rule that you agreed applies in Judge Torpy's example doesn't apply here. And if his contract with the builder is land and house, and the guy won't build the house, you said, well, you're entitled to specific performance. The contract doesn't say the land is only $400,000. It just says land and building $1 million. But you agree with me that with adequate proof, the court could come in and say, well, the land is worth X, whatever that number is. I just don't see why that same thing isn't true here. I agree with you that the terms for just a sale of bare land aren't present here. I just have a hard time understanding why the same rule that I thought you agreed applied in Judge Torpey's example doesn't apply here, albeit it's a much more complicated thing to determine.
Judge, I think the argument is it would require the parties to rewrite the contract. That wasn't the deal, the conveyance of the acquired property. But I think, let me just bring, if I might for a moment, bring it back for a second, that if this court believes specific performance is permissible, let's accept that for a moment. But the real question, though, is whether or not the specific performance claims are founded upon the agreements under the strict requirements test of American Legion. And under that exception to 4823 subsection 2, which is a much higher standard in that it gives the proponent of the lis pendens the absolute right to maintain the lis pendens, abrogates my client's right to request a bond. In that scenario, the specific performance claims are not founded upon the agreements. Even if Your Honor...
What does founded upon the agreement mean?
As the American Legion Court said...
Just tell me what it means. You don't need to look at the case. I mean, just tell me what it means.
Strict requirement that the lawsuit be based specifically on the
It means
term,
based on the agreement, right? Isn't that what it means?
but specifically on the terms and provisions in the agreement.
Well, when I say that something is based on an agreement, that means to me that it's based on the terms and conditions in the agreement. I don't know what that adds to it, counsel. So is it based on the agreement? Sure, it's based on the agreement. They had an agreement that related to this land, and they were going to end up with it if everybody performed. Why isn't it based on the agreement?
It's not based on the agreement, Your Honor, because the agreement's never provided for the conveyance of only the acquired property as raw land.
You keep falling back on that point. That's the one I'm really struggling with. So,
And I think that's the strict requirement of the Florida Supreme Court.
so anytime, the rule of law that you espouse here is that in any suit in any suit related to a contract for the conveyance of land where there's anything else that's included and the seller cannot perform the other else, that specific performance doesn't lie. I mean, I think that's the rule of law you espouse.
I don't know if it's that broad of a reach, Your Honor, but I think in this specific case that the specific performance of only the acquired property is not a term or provision in the agreement.
Okay.
The parties never agreed to that.
Counsel, you've exhausted your time. I'm going to give you a half minute for rebuttal if you
Thank you, Your
really
Honor.
need it.
Thank you, Judge.
Good morning. May it please the Court. John Hamilton on behalf of the respondents here.
Mr. Hamilton, he's relied heavily on the New Vision case. Would you address why New Vision doesn't apply?
Well, the New Vision case is a fair nexus case rather than a duly recorded instrument case. And when you get into the fair nexus inquiry, you do look at, the courts have said it's a low threshold, but you do look at whether there's a good faith viable claim, which will, I think, necessitate some examination of the merits of the claim. But that's not what we have here. We don't have the fair nexus inquiry having been made by the trial court here because the trial court didn't get to that point. And you don't get to that point, you don't start looking at the merits until after you've not satisfied the duly recorded instrument test of Mohican Valley and 4823 subsection 3.
Are these contracts duly recorded instruments?
Absolutely. They've conceded that. They conceded
Well,
it
aside
twice.
from their concession, are they?
They are duly recorded because I would say yes, because the contract expressly provides that they can be recorded, and I don't know of any legal prohibition against that. I think that issue's off the table as a result of that provision and as a result of the concession that they twice made.
Are they instruments? Is any document an instrument, or does that phrase connote something that is more customarily recorded, like a deed or something like that?
The candid answer, Your Honors, I don't know. I don't know of any reason to believe that these wouldn't qualify as instruments within the meaning of that statute. It wasn't an issue that was raised and therefore wasn't one that I reasoned.
It was a creative legal maneuver. Was that your idea, Mr. Hamilton?
It was not, Your Honor.
To run down there and record those contracts?
I did not do that. I had nothing to do with that, Your Honor.
All right.
Mr. Hamilton, let me ask you specifically, when I compare the lis pendens, and more specifically the legal description that's attached to the lis pendens with a contract, tell me how I determine, if I was looking only at the contract, how would I be able to determine that the dirt that I'm concerned with is the same dirt that's referenced in the more traditional meets and bounds descriptions, et cetera, found in your list pendants?
Because Florida is an inquiry notice jurisdiction. A person is charged, the world is charged, with not only the precise things that are in the public record, but also any inquiry that those would give rise to if those inquiries are duly prosecuted. The recorded contracts, and under the recording statute, documents have to be recorded according to not just date and time that they're recorded and type of instrument, but also the parties to the instrument. So anybody doing a title search is going to see these documents when they find out the seller matches the seller they propose to buy from. We're taking a hypothetical seller here, or a buyer, excuse me. The seller they propose to purchase from also matches the seller on these recorded instruments. And if you look at the instruments themselves, you see a visual depiction of where this property is, the property that's the subject of the agreement. It's right there on Lake Ruby. It's next to Apopka Vineland Road and 10th Street and Ruby Lake Road. And if that doesn't give you inquiry notice to check and find out whether your property in the same area is within the scope of that agreement, I don't know what else would qualify for inquiry notice. So absolutely a buyer is on notice and the world is on notice of the Emerald entity's interest in this property, irrespective of the absence of a legal description in these contracts.
If I understand how the transaction was structured, BVC was supposed to acquire property from third parties, develop it, and then you guys would share in the proceeds.
Essentially, yes.
Essentially.
Yes.
And your contention, as I understand it, is that BVC has not acquired the bulk of the property. They've only acquired a small amount of what was contemplated.
I'm not sure the precise percentages, but I think that's probably an accurate statement. They acquired some, but not all.
Does your list pendants encompass property other than what BVC actually acquired?
No.
Okay, then that ends my line of question.
No, I think we'd have quite a different case if we were trying to put a lien on property that was not owned by the defendant here.
Okay. I have no other questions on that topic.
Okay.
That simple answer answered my question. Thank you.
I mean, I should qualify that. I mean, we have no reason to believe that it does, and it's never been suggested that it does. I mean, I'm not a surveyor. I haven't gone out there, but the record.
I understand. Your intention was to affect only the property that BVC actually acquired with the recordation of your LP.
That's correct, Your Honor. So, if you get to the test for Mohican Valley on whether an action is based upon a duly recorded instrument, these are specific performance claims predicated on alleged breaches of written contracts that have admittedly been duly recorded, contracts for the precise property that's the subject of these specific performance claims. I think once you make that statement, you answer the question as to whether the test under Mohican Valley and the statute has been satisfied. It does satisfy that test. And it seems to me that under the case law, once you get to that point, you stop. You don't look at things such as fair nexus. You don't look at bond issues. You don't look at the merits of the underlying claim. And that's what they've done here, I suggest to the court, is that they've moved into the area of arguing the merits of the specific performance claims themselves as if they were appealing from a hypothetical denial of a motion to dismiss that claim or a hypothetical summary judgment or adverse judgment on the merits or something of that nature, something the trial court has not done, and something that wouldn't be a proper subject for either an appeal from a non-final order or certiorari review in any event. But if you do talk about the merits, I think your argument not only cannot be reconciled with the law example that you, Judge Torpy, came up with, but I don't think it can be reconciled with the existing case law. The Black versus Clifton case, the Coate versus Hale case, the Beaumont Lakes case recently out of the second DCA, and the older second DCA case, the Kubasek case. I mean, those cases stand, I think, pretty clearly for the proposition that if a seller cannot fully perform the contract, the buyer is entitled to specific performance for so much of the contract that the seller can perform.
Are there any cases, Mr. Hamilton, that say that the recordation of a run-of-the-mill contract for sale and purchase that's a duly recorded instrument?
I don't know the answer to that, Your Honor. I'd be happy if you'd like to go back and research that and submit something supplemental on that. But because it wasn't an issue that was ever raised, I didn't look at that.
I don't blame you.
I'll take concessions when I can get them, Your Honor. So I had that one to work with. And I think every argument that they have made here would apply or would have applied equally in the four cases that I mentioned, the Black Coats, Coopasek, and the Vermont Lakes case. None of those cases involve specific performance of none of those, let me say it this way, none of those cases involved a seller who was able to perform fully the contract and just refused to do so. All of them had a deficiency, an area of non-performance that affected the seller's ability to perform. Yet the courts nonetheless said, I think quite sensibly and commonsensically, that the buyer was entitled to obtain whatever the seller could perform and damages for whatever was left over, whatever the seller could not perform. And the rationale, and it fully comports with equitable principles, is that a seller should not be able to escape the remedy of specific performance through the acts of its own non-performance. And that, it seems to me, is precisely what we have here. It may be a more complex situation than the single lot and single house, but it's exactly the same principle. And let me say, sort of finally on this point, even if I'm wrong, and even if the trial court was wrong on this, I don't think you can say with a straight face that this was a departure of a clearly established principle of law. And if you don't have that, then you don't have a departure from the essential requirements of law, and you don't have certiorari. So this would not be an appropriate basis to grant certiorari, I would think, even if they are correct on their merits, which they're not. So for these reasons, unless there's any further questions, I would ask that the petition be denied.
Thank you, Mr. Anderson. Counsel, you've got a half minute.
Thank you, Your Honor.
Use it wisely.
Thank you. Your Honors, I believe that I would respectfully disagree that the recording of the agreements with the lot subdivision proposed layout of future roads and where it's going to lay around the lake would be sufficient notice to third parties of Emerald entities' alleged legal or equitable interest in the property. That's point number one. But I don't think under Mohican Valley they've met that test. Number two, it certainly makes practical and logical sense that if under a fair nexus analysis the court can test the sufficiency of specific performance claims, it certainly would make sense that the court would look to the sufficiency of the specific performance claims under the heightened threshold determination, giving the proponent of the lis pendens a matter of right to maintain the lis pendens and no opportunity for the property holder to request a bond. This court has certainly done that in the following cases: Mohican Valley, the Avalon Court did it, New Vision, and the Suarez case.
Counsel, you've exhausted your time. Thank you.
Thank you
We'll
very
take
much.
your point. All right, it's about